During a House Judiciary Committee markup, lawmakers debated a bill that would require disclosure of third-party litigation funding, raising questions about transparency, access to justice, and potential foreign influence in U.S. courts.
For an opening statement.
Mr. Chairman, I will have an amendment. However, as an introduction to the bill, we've made virtually all the amendments that were possible in from the previous version of the bill. We've reached out to every group on the left and the right and satisfied everyone we could satisfy. It is clear you cannot satisfy everyone because of a problem that exists within the court system. In some courts, Mr. Chairman, a judge will routinely ask for the source and information for third-party funders of litigation, because clearly the third-party funder has at least some likely influence on whether or not the product can be settled, and in most cases, particularly cases that involve intellectual property, they absolutely need to be known if you're going to write a protective order that covers whether or not they should be excluded. Having said that, currently it's inconsistent. In Delaware, where one judge began doing it routinely, he simply doesn't get the cases anymore. In others, where they do it periodically, they will probably be avoided. Those who never ask are the favorites of trolling organizations and plaintiffs' lawyers who are using third-party funding that for some reason they are unwilling to divulge their source. Having said that, there were legitimate concerns brought up in this legislation early, and we have addressed those. The first and foremost, the amendment, not mine, but that was offered that made the most sense was that in all cases, the judge will start with an in-camera review, thus determining whether or not the defendant has a reasonable need to know it, but at the same time letting the judge know whether or not there's a need for this to affect protective order and other activities. You might ask, what is the problem with this bill then, if we've met at all? The problem is there's dark money. And when I say dark money, I mean sources that people are ashamed to say where they're getting it from. We have put in protections so that people who simply contribute money to a cause are not discoverable. We've put in additionally that you are not discoverable if, in fact, you do not share in the profits, meaning that if an organization or group simply backs the cost of the bill, including the return of their original investment, they still are exempt from this. The only way to actually be discoverable and potentially that information turned over to the defendant is if, in fact, you are effectively the plaintiff, meaning you share in the profits and likely share in the ability to settle or not settle. That means that when there's a request for a mediation conference, there's an expectation that the person coming has the right to make a settlement and not, in fact, simply to arrive and go back to an unknown source for those settlements. Today, we will undoubtedly hear a number of amendments coming from a number of people. I've been informed that those amendments seek to gut the bill, and I will be opposing likely all of them. None of them have been presented in advance, which is not in the spirit of finding a solution. I will address in closing one item that has been brought to my attention. I was a small inventor for more than 20 years. I have 37 patents. I know full well how expensive it is to take on the big guys, including Chrysler Corporation and others. Having said that, third-party funding can be essential to do a $3, $4, $5 million case, even if, in fact, you expect to be successful. It may not be something you can bet the farm on if you don't already own the farm. For that reason, we have made every effort to make sure that there is nothing that would diminish or reduce the ability to get third-party funding unless that third-party funding comes from George Soros, who in an un-American way wants to stop something, or the Chinese communist who want to slow our technology, or, for example, Huawei, that repeatedly seeks to have trolls who will, in fact, try to stop 5G and other developing technologies by endless litigation, slowing down, or in some cases, even stopping development. All of this is the reason this bill is before us today. Mr. Chairman, I look forward to proceeding forward. I yield back.
The gentleman yields back. With the chair now recognizes the gentlelady from Vermont for an opening statement.
Thank you, Mr. Chairman. Third-party litigation funding, or TPLF, is exactly what it sounds like. Third parties invest in litigation in return for a share of the contingency fee or the damages awarded should the party they've invested in win. It represents a practical solution to the problem that many Americans face when they need to go to court to obtain justice. Litigation is often prohibitively expensive, and third-party litigation funding helps ensure that no person is denied their day in court because of financial barriers. Third-party litigation funding levels the playing field for ordinary Americans who face powerful corporations, which is exactly why major business interests are now working to discredit it. These corporate interests want you to believe that TLPF agreements are nefarious. They suggest that third-party funding is somehow giving ordinary people an unfair advantage against these large and powerful corporations. They have proposed this bill that they say brings transparency to the system. Less than 2 months ago, we were scheduled to consider a bill just like this very proposal, one that promised to bring again, quote, transparency to litigation. But groups representing the people and organizations who rely on TPLF, Republicans and Democrats alike, told us how the bill might end this form of litigation altogether. And the bill was pulled from Markup. For a moment, it appeared that this bad idea was finally behind us, yet today we're presented with largely the same text under a different name. Some of our colleagues across the aisle say this is a negotiated text. Well, I know the ranking member certainly was not asked for his opinion, and if he'd been asked, he would have said that the minuscule change that they're touting as a grand compromise was already necessary to comply with the Constitution. That's right, in 1960, the Supreme Court unanimously agreed in Bates v. Little Rock that requiring the NAACP to disclose its contributors unjustly interfered with the members' freedom of association, which is protected by the Due Process Clause of the 14th Amendment from invasion by the states. So this new text suggests that member and donor lists of TPLF funders don't have to be disclosed in some situations, is simply a restatement of governing law. In any agreement where the members and donors have a financial interest in the outcome, which happens frequently with TPLF, would still require full disclosure under this bill. All of the risk is still there, and for all practical purposes, this bill remains unchanged. Whether we call it protecting TPLF or encouraging transparency, Americans can see the truth. All today's bill does is advance powerful corporations' ability to escape responsibility for the harm that they cause communities. The fact is that this bill is not about fairness. Opponents of third-party litigation funding haven't suddenly seen the light and want to protect TPLF. And this bill is certainly not about transparency. If it were, my colleagues would at least acknowledge that both state and federal judges already have the power to demand this information from litigants. If more transparency is necessary in any of these cases, courts are free to demand it. Instead, these bills are about stacking the deck in favor of big business so corporations that break the law can drag out cases and dodge accountability. By forcing plaintiffs to reveal their backers, these bills will let the deep-pocketed defendants stall, intimidate, and drive up costs until the plaintiff is forced to give up. And increasing the disclosures needed to file a claim in court makes third-party funding more cumbersome and expensive. And it is an attack on the litigation victories that third-party litigation funding has enabled. For example, the famous 1993 lawsuit brought by Aaron Brockovich against Pacific Gas and Electric Company for dumping a carcinogen into the water supply of Hinckley, California, which was partially funded by an outside provider. The women and small law firms who sued Pfizer to prove their drug caused a breast cancer epidemic could not have done so without TPLF. Victims of the opioid crisis were able to sue the Sacklers to bring justice to the over 650,000 individuals who died during the epidemic thanks to TPLF. These are just a few examples of people who never could have gotten their day in court without outside funding. Everyday Americans cannot afford basic health insurance or groceries or housing, yet my colleagues across the aisle suggest that if they're harmed by a major manufacturer or corporation, they should just pay for it themselves. The bill stacks the deck in favor of corporate interests and against the people, and I intend to vote no. And I also want to bring up the point that opposition to the abusive transparency measures in this bill is actually, in fact, bipartisan. When some Senate Republicans tried to all but end TPLF in the big ugly bill earlier this year, other Republicans stood on principle to say that ending it was wrong. And this past June, Laura Loomer posted on X, quote, litigation finance is a critical weapon for the little guy, empowering consumers, whistleblowers, and small inventors to take on corporate titans. And last week, Gene Hamilton of American First Legal wrote that he is continuing to oppose the bill. He wrote this on X. Now, American First Legal and I don't agree on much, but we have common ground in the opinion that, as he wrote, quote, the bill only serves the interests of the Chamber of Commerce and not the American people. So again, I plan to vote no. I urge my colleagues to vote with me, and I yield back.
Gentlelady yields back without objection. All other opening statements will be included in the record. The chair now recognizes the gentleman from California to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment to the deck.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from California to explain the amendment.
Chairman, the amendment is not substantive in nature, but simply as a substitute changes the year and title of the bill. It does not change the substance of the base bill.
Gentleman yields back. Gentleman from Wisconsin, Mr. Fitzgerald is recognized.
Thank you, Mr. Chairman. I'm proud to support my colleague, Mr. Ice's bill, the Protecting Third-Party Litigation Funding from Abuse Act, and urge its passage. Third-party litigation funding, or TPLF, has grown quietly but explosively over the last decade. According to a 2022 GAO report, TPLF was estimated to be a $12 billion industry in 2021, although some sources now put it upwards of $18 billion today. Litigation finance offers a high-risk, high-reward strategy. And some in front of this committee have even equated it to basically gambling. Now there is nothing inherently wrong with financing a lawsuit. I share my colleague's sympathy for the small business or for the single investor who's forced to defend themselves against Fortune 500 corporation with deep pockets. In those instances, TPLF helps create a level playing field, and this legislation would not stop that. But when the financing is undisclosed, when it shifts control of litigation from a plaintiff to a silent investor, and when it potentially places decisions about U.S. lawsuits in the hands of foreign entities, including those with ties to geopolitical rivals, Congress has responsibility to act on this. Excuse me. This is precisely what H.R. 7015 does. It simply requires transparency. It requires parties to disclose to the judge who's doing the financing on the lawsuit and what rights those funders have acquired. The reason transparency is essential is because TPLF can undermine the most basic expectation of our legal system, that clients are in control of their own cases. This is not a hypothetical scenario. It is an established pattern. The most famous example was in 2023 when Cisco, the U.S. food distributor, wanted to settle a price-fixing lawsuit, but its TPLF funder, Burford Capital, countersued Cisco because under the terms of the TPLF agreement, Burford had final say in any settlement discussions. In other words, Cisco wanted to settle, but Burford wanted a higher return on investment. In several instances, funding contracts have given investors veto power over strategic decisions such as which lawyer to hire, whether and when to settle, whether to appeal, or whether to pursue certain claims. And because these arrangements are usually secret, courts are left unable to access conflicts of interest or other ethical issues that arise from these arrangements. Transparency is not only important for protecting a client's interest, but also critical for protecting national security. We know that foreign adversaries are increasingly sophisticated in using economic and legal tools to influence U.S. institutions. TPLF offers a direct avenue for foreign actors to inject capital into U.S. litigation and potentially shape legal outcomes affecting strategic industries, intellectual property, or sensitive technologies. Consider a scenario where a foreign-owned investment firm funds mass litigation targeting an American defense manufacturer. By steering litigation strategy from prolonging discovery to punishing for disclosure of proprietary information, a foreign actor could gain access to data, to sensitive data, or weaken a critical supply chain partner. And because TPLF agreements are currently hidden, neither the court, nor the government, nor the American public would know who is ultimately pulling the strings. Or consider complex intellectual property litigation. A fund with ties to a foreign competitor could bankroll lawsuits intended to drain resources, pressure firms into an unfavorable settlement or licensing agreement, or force disclosure of trade secrets. And better yet, they could slow or altogether stop the rollout of key technology through an injunction. These are not speculative concerns. We have already witnessed foreign sovereign wealth funds invest in U.S. patent lawsuits for the purposes of gaining access to U.S. intellectual property. Disclosure will ensure that the courts knows who's involved and can take appropriate steps in response during litigation. It ensures that when strategic decisions are made in American courtrooms, they are not secretly influenced by entities whose interests may be adverse to their own. Some will argue that disclosure imposes a burden, but transparency is not a burden, it's a safeguard. The only parties disadvantaged by disclosure are those who benefit from secrecy. Our courts routinely require disclosure of financial interests, insurance, ownership structures, and conflicts. Extending that practice to litigation funders is simple fairness. In passing H.R. 7015, we reaffirm a basic principle, that our civil justice system should be predictable, neutral, and accessible. I urge my colleagues to support this common sense bill. Our courts, our litigants, and our national security deserve nothing less. Thank you, and I yield back.
Gentleman yields back. Gentlelady from Washington is recognized.
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
When a bill similar to this one was scheduled for markup a few months ago, my colleagues on the other side and I had a very robust back and forth about the consequences of disclosing third-party litigation funding. And I expressed my concern then that disclosure would give large corporate defendants a unique and undue advantage in a legal system that's already rigged against ordinary workers, consumers, victims, survivors, and small businesses. It would do this by arming corporate defendants with knowledge about how much money the victim has to prove and sustain their case, and it would allow the corporation to bury the victim in costs and draw out the case until it becomes financially impossible for the victim to continue pursuing the case. Now, these weren't just Democratic concerns. Conservative groups like America First Legal, co-founded by Stephen Miller, the Oversight Project, a spinoff of the Heritage Foundation, also strongly opposed the legislation because disclosure would discourage funders from investing in litigation for fear of negative exposure or harassment, likely in violation of their First Amendment freedom of association. So when I learned that the bill text had changed, I was hopeful that maybe these changes were going to address some of those concerns. But sadly, the changes have only further tilted the scales of justice in favor of corporations by, for example, making the disclosed information admissible in court and requiring the disclosure much earlier in the litigation. And while the bill now prohibits the disclosure of donor lists, that prohibition exempts all donors who provide third-party litigation funding, an exception that essentially swallows the rule. So it shouldn't be surprising that there are conservative groups as well as liberal groups that still oppose this bill. Access to justice is the backbone of any democratic society, and in today's economy, there are just too many people who are priced out of the very system that exists to protect them. Working-class Americans with very few resources are being harmed by massive, giant corporations that are responsible for all kinds of wrongdoing. These include mothers suing a pharmaceutical company for its cancerous baby powder, families of victims of school shootings suing a gun manufacturer for marketing AR-15s to teenagers, small inventors suing large companies for stealing their creations, and female employees suing an insurance company for discriminating against them through lower pay and fewer promotions. These vulnerable Americans are facing massive corporations. They're armed with a lot of money, plenty of money, and they're not afraid to use it as a bludgeon to make sure that any challenge to their agenda is bludgeoned down before it even gets started. Litigation is incredibly expensive, and that cost barrier alone can determine who wins and who never gets heard. Third-party litigation funding gives working-class Americans a fighting chance at holding corporations accountable. This bill is not just harmful, it's also unnecessary in the sense that under current law, judges already have the power to review litigation, financing agreements, and ensure that those agreements are fair and ethical and compliant with the law. Judges are already trusted to supervise the relationship between attorneys, clients, and third parties when it comes to attorney fees and class actions and bankruptcy settlements. And there's no reason that they can't continue to be trusted to oversee litigation financing agreements. With this bill, you would block ordinary consumers, workers, mom and pop shops from holding big corporations accountable for causing cancer, for contributing to mass shootings, for stealing inventions, for discriminating against their workers. And so I hope that my colleagues on both sides will vote no, reflecting the opinion that's coming from both conservative groups and liberal groups in this particular situation. I urge my colleagues to vote no, and I yield back.
Gentlelady yields back.
Move to strike the last word.
Gentleman from Kentucky is recognized.
You know, a lot of the fights or the debates up here are left versus right, and there are a few of them that aren't left versus right. This is one of those. This is the big guys versus the little guys, and we don't have enough people up here speaking for the little guys, which could include patent holders who've taken a beating legislatively in the courts over the last decade or 2 decades and are struggling. This is just another effort to keep them from getting their day in court. There's a boogeyman here, which is China or other foreign adversaries. If that were really what this bill was going to go after, we could narrowly tailor a bill that did that. And in fact, I'll offer an amendment to make this bill into that. But that is not what this bill is. This bill is so overly broad that it will basically deter investments in legitimate claims that startups and small plaintiffs have. The bill's language is so expansive that it may require disclosure of entire chains of financial interests, including venture capitalists, limited partners, pension funds, or even shareholders of public companies. It compels submission of funding agreements to opposing parties without protections for proprietary information like funding amounts, waterfall structures, or investment terms, information that has no relevance to the legal merits of the case. But it could help the defendants, the big guys, know how deep your pockets are and how long they're going to have to go to starve you out in the litigation. Even the requirement for in-camera review is problematic. Defendants are not required to disclose indemnification agreements, yet plaintiffs must expose sensitive financial backing that could be weaponized through retaliation, harassment, or reputational damage. Registered investment advisors, already subject to full FEC oversight, would be swept into disclosure mandates, duplicating regulations without any national security justification. And by admitting that these disclosures are inadmissible and not discoverable, the bill concedes that they serve no evidentiary purpose and are instead designed to chill litigation finance, ultimately benefiting large corporate defendants. You don't have to take my word for it. Listen to the groups on the outside, some conservative, some liberal, but all trying to represent everyday Americans who deserve their day in court. And if this bill passes, it will squelch their voice by cutting off their funding, by intimidating their financiers. And that's what the big guys would love. So I'm going to be opposed to this bill, and I will offer amendments, and hopefully they will be accepted because they're offered in good faith to do what we're being told the bill does, which is to keep foreign adversaries from infiltrating our courts and changing the balance of justice in the United States. And with that, I yield back.
Gentleman yields back. Gentleman from North Carolina is recognized.
Thank you very much, Mr. Chairman, and I couldn't agree more with Mr. Massey. In particular, this is going to hurt small patent holders who do not have the ability to finance their inventions, do not have the ability when big corporations come in and try to steal their inventions. It is going to, the definition that we have, by saying any person entitled to any payment or thing of value in the act is overbroad. It's going to threaten limited partnerships, equity investors, family offices, a wide variety of things. And I agree, if we have a concern about foreign investment, then we can have a very narrow rule that talks about when it's a foreign investment or a foreign investment that is not an investor in the underlying invention or patent. But the other thing that I want to say about this David versus Goliath situation is that we're seeing even more roadblocks put in the way of people who want to file litigation against large players. We're seeing limits in how people do class actions. We're seeing limits in how you can get an injunction and whether it just applies to you or can apply to somebody else. All of these things make it harder and harder for people who don't have means to protect their intellectual property, protect their rights, protect their safety, protect their families. And so when we do things that make it harder for people to get access to the courts, it must be extremely narrowly tailored, and there must be a compelling interest for doing it. What I'm seeing right now is that the compelling interest is the profits of people who might be in litigation. And that is not sufficient for me. I will be voting no, and I'm glad that people on both sides of the aisle are seeing it the same way, and I yield back.
Gentleman yields back. Gentleman from Texas is recognized.
Thank the chairman. And I would like to associate myself with the remarks of the gentleman from Kentucky. I will also not be supporting the legislation as drafted. Look, you know, there are kind of three ways things go in this world. You get ground out by the market, a market which, you know, I generally support existing, but people can get ground out by government and the market and so forth. But you got to have recourse. You either have some regulatory constraint, which I'm not overly fond of, or you have litigation where you can go exercise your rights to go push back when that system creates issues. And the trial bar has often done things that create a bad reputation, but as have corporations and as have government and as have bad regulations. In this environment here, I feel that this is, and I'll align myself with what my friend from Kentucky said, you know, lining up with the big guy versus the little guy as a general proposition. I think this is more doing the kind of Chamber of Commerce bidding than it is in trying to create a structure that I think works the way it should. And so from, you know, my standpoint, I am interested in what my friend from Kentucky might put forward to limit it, to target it. I understand the merits behind wanting to do something here. I get it. And I certainly believe it was done in a good spirit by my colleague who introduced the legislation. But, look, I think this is going to create an environment.
The debate highlighted sharp divisions over whether additional disclosure requirements would improve transparency or restrict access to the courts, with lawmakers continuing to consider potential amendments and next steps.